Hello viewers, warm greetings of the day. In today's lecture, we shall be discussing capital punishment in India. Crime has been a part of human society since time immemorial. Criminologists and penologists from across different parts of the world and at different points of time have been undertaking extensive research into the biological, psychological, sociological explanations to crime causation, and the purpose has been to come up with a penal policy. Punishment is an important aspect governing the criminal justice administration, not only due to its deterrent effect, nevertheless, it also serves a larger community interest, and more recently, punishment is being viewed with a reformative objective, that is, the consideration that the criminal is a diseased person suffering from the disease of crime, and the purpose of law is to cure him of the disease through a suitable reformative approach. One debatable aspect regarding penology is capital punishment, that is, justified death of the wrongdoer after following the due process of the law and giving him or her a fair trial and a fair opportunity of defending oneself. Capital punishment connotes a method of legal vengeance whereby justice is promoted and criminals are deterred from committing serious offences that attract death penalty as a mode of punishment. Death penalty or capital punishment has been in existence since ancient times in different penal systems across the world like India, ancient Rome, Greece, England and France, to name a few countries. It was justified on the ground of prevention of miscarriage of justice, as it was considered that if a man without any justification kills another, he too must lose his life. From ancient times until the later part of the 18th century and in all parts of the world, the threat of punishment by death has been widely accepted as an effective penal weapon of social control, even to the extent to which it was enforced varied between countries and in different periods. For example, it was not enforced at all in Japan during the Heian period of 794 to 1185 AD. According to the historian Stuart Banner, the primary purpose of capital punishment was the emphatic display of power, a reminder of what the state could do to those who broke its laws. The link between cause and effect, between the commission of crime and the imposition of death sentence was made as conspicuous as could be. In many countries during the 17th and 18th centuries, death became the appointed punishment for an ever widening range of offences, varying enormously in their gravity. As the British expanded their rule in different parts of the world, capital punishment also got the legal sanction in different colonies of the British Empire. Those who did not support the death penalty found support in the writings of European theorists like Montesquieu, Voltaire, Bentham, John Sellers and John Howard. However, it was Cesar Beccaria 1767 essay on crime and capital punishment that had especially a very strong impact throughout the world. In this essay, Beccaria theorized that there was no justification for the state taking of life. With this, we move on to the historical perspective on capital punishment. As discussed previously, capital punishment was a sanctioned form of legal punishment in different parts of the world and was justified on the ground that killing of a fellow human being was the greatest form of sin. In the ancient Indian context, capital punishment was used as a form of punishment in serious offences. However, the modes of execution were extremely barbarous, like stoning the wrongdoer to death, throwing the accused in boiling water, strangulation, throwing him before wild beasts, etc. In the holy texts of Mahabharata and Ramayana, as well as manuscript, Vadadand has been specifically referred to. In those times, capital punishment was awarded as a justification for the serious crime as well as for serving the twin objective of retribution and deterrence. It is pertinent to make a reference to the justification given by King Damatsena when he stated, if the offenders were leniently let off, crimes were bound to multiply. True ahimsa lay in the execution of unworthy persons, and therefore execution of unwanted criminals was perfectly justified. Thus, the ancient Hindu rulers justified capital punishment, and Manu, the ancient Hindu lawmaker, in his writings has also justified the same. As we make a reference to the ancient Indian history, we find that the Mughals during their rule in India adopted an even more barbarous policy with regard to imposition and execution of capital punishment. Later, the East India Company came to India with the purpose of trade and commerce. However, they soon established their mighty power and control over India and colonized it. The British overhauled the legal system for an effective and uniform framework for better governance. The Indian Penal Code 1860 was also enacted during the British rule, and capital punishment was incorporated for serious offences and in particular offences against the state, for instance, waging of war against the state. The British wanted to deal with any act against their oppressive rule with an iron fist. Public executions were practiced. Moving on to the next part, that is capital punishment in post-independence era. After a long struggle for freedom, India finally gained independence from the British rule, and in due course of time, a written constitution was framed for the working of the infant democracy. The Indian Constitution, one of the lengthiest constitutions of the world, protects and promotes the fundamental rights of its citizens, particularly Article 21, which guarantees the right to life and personal liberty. This right has been broadly interpreted by the Supreme Court of India as being inclusive of every right that makes the right to life more meaningful. However, the constitutional validity of capital punishment has been challenged as being violative of the right to life. The judicial perspective, through a catena of case laws, leans in favor of awarding capital punishment as a form of punishment only in the rarest of rare cases. Death penalty as a form of punishment was retained. However, in the case of Lakshma Devi versus state of Rajasthan, public hanging was declared as unconstitutional. Capital punishment as a form of punishment has remained a debatable issue. Its efficacy has time and again been questioned. Desirability of this form of punishment vis-a-vis the reformative approach to punishment has been viewed from different perspectives, that is individual, victim, society, criminal, penal and judicial as well. Most recently, by way of the Criminal Law Amendment Act 2018, Indian lawmakers have increased the category of offences for which death sentence may be awarded. Thus, a clear dichotomy can be witnessed here, as on one hand, most of the countries are abolishing the death sentence, whereas India has actually increased the ambit and scope of this form of punishment. The popular public opinion is strongly in favor of retention of capital punishment for serious offenders, rapists and terrorists. In the recent past, Ajmal Kasab, the lone surviving terrorist of the Mumbai carnage, was executed for waging a war against India. The multiple terror attacks on Mumbai were of a large enormity. The nefarious acts of the foreign terrorists were brutal, and the attack was nothing short of waging war against the government of India. In the landmark judgment of Muhammad Ajmal Muhammad Amir Kasab versus State of Maharashtra, the court held that the terrorist attack on Mumbai was aimed at India and the Indians. People were killed only because they were Indians or they were foreign nationals on Indian soil. It was to embarrass India, to hit at its financial center, to give rise to communal tension, create internal strife and insurgency. The attack was nothing short of waging war. Irrespective of the fact that the accused was involved in the attack at only one location, his conviction for waging war was justified. Moving on to the next part of the lecture, that is constitutional validity of capital punishment in India. As discussed in the previous part, death sentence was a sanctioned form of punishment since ancient times. As reflected in the historical context, the British incorporated the same in the penal policy while governing India. After independence, till date, it is a mode of punishment. In the Indian context, capital punishment is a part of the substantive penal provisions. The Indian Penal Code 1860, a colonial legacy, provides for death penalty in serious offences like murder, waging war against the state, rape of minor children, dacoity with murder, etc. The scope of capital punishment has been considerably enlarged by subsequent amendments in the Indian Penal Code. In 2013, the Criminal Law Amendment Act introduced new offences, thereby extending the reach of this form of punishment. Objective of insertion of new sections was to provide a deterrent punishment to sexual offenders. However, the sexual crime against women did not abate. The Kathua gang rape case of an 8-year-old girl was the tip of the iceberg and led to another set of significant amendments in the IPC, whereby the provisions with regards to rape were further strengthened. As discussed previously, the legal framework provides death penalty for several offences. However, death penalty is often an alternative form of punishment, and life imprisonment is also the other mode of punishing the convict. The constitutional validity of death sentence has often been challenged, and the first important judicial decision in this regard came in the case of Jagmohan Singh versus State of Uttar Pradesh, wherein it was contended that the execution of death sentence takes away all the fundamental rights guaranteed under the Constitution, and thus death penalty is unreasonable and not in the public interest. The second point of contention was that the judicial discretion with respect to awarding of capital punishment was not based on any standards as to how death penalty was preferred over life imprisonment. The third contention was that death penalty was highly violative of Article 14 of the Indian Constitution, because two accused found guilty of murder on similar facts were liable to be treated differently, one being executed till death and the other given life imprisonment. The last contention was that the legal provisions did not provide a procedure for the trial and factors and circumstances crucial for making the choice between capital punishment and life imprisonment. In the above case, the apex court observed, death penalty is constitutional and the deprivation of life is permissible for being recognized as permissible punishment by the constitution makers. In Rajendra Prasad versus State of Uttar Pradesh, Justice Krishna Iyer ruled that the death penalty violates Articles 14, 19 and 21 of the Constitution of India. He further said that to impose death penalty, special reasons should be recorded before imposing it, and it must be imposed only in extraordinary circumstances. In the case of Bachan Singh versus State of Punjab, the larger bench of the Supreme Court overruled its earlier decision in Rajendra Prasad's case, observed that death penalty as an alternative punishment for murder is not unreasonable and hence not violative of Articles 14, 19 and 21 of the Constitution of India. The court further observed, the question whether or not death penalty serves any penological purpose is a difficult, complex and intricate issue. It has evoked strong divergent views, notwithstanding the view of the abolitionists to the contrary. A very large segment of people the world over, including sociologists, jurists, judges and administrators, still firmly believe in the worth and necessity of capital punishment for the protection of the society. Thus, the courts had to decide whether to award death penalty or life imprisonment to the offender, depending upon the aggravating and the mitigating circumstances. To streamline the judicial process of awarding death penalty as an alternative, the Supreme Court in Machi Singh and others versus State of Punjab propounded the rarest of rare doctrine with regards to imposition of capital punishment by providing a 5-point formula to be considered by the judge while awarding death sentence. The first point is the manner in which the offence was committed. If it was committed with extreme brutality, such as burning the victim alive or cutting the victim's body parts into pieces, then in such circumstances it would be a fit case to be considered as the rarest of rare. Secondly, when the motive reveals depravity and meanness of the murderer. Thirdly, when the murder is socially abhorrent, such as bride burning or killing of a Harijan or infanticide. Fourthly, when the magnitude of the offence is enormous, as in the case of multiple murders. Fifth, when the victim is an innocent child, a helpless woman or a reputed figure like the murder of a political functionary. The Supreme Court further made the observation that in order to apply these guidelines, the following questions may be asked and answered. The first, is there something uncommon about the crime which renders sentence of life imprisonment inadequate and calls for a death penalty? Are there circumstances of the crime such that there is no alternative but to impose death sentence even after according maximum weightage to the mitigating circumstances which speaks in favor of the offender? Furthermore, in the case of Deena versus State of Uttar Pradesh, the Supreme Court cautioned that the collective conscience of the community must be shocked, if so the judge may award death penalty. In the case of Triveni Bain versus State of Gujarat, the Supreme Court asserted that the Constitution of India does not prohibit death penalty. Thus, from the above, it can be understood that death penalty has been considered to be constitutionally valid in India, as the Constitution does not expressly prohibit the same. However, Article 21 deals with the right to life and personal liberty and says that no person can be deprived of his life or personal liberty except according to a procedure established by law. Even though the judges have been bestowed with judicial discretion to make a choice between life imprisonment and death penalty, as per the constitutional mandate, they are expected to exercise utmost care and caution in this regard. To conclude, capital punishment has been a part of the penal policy throughout the world and a recognized mode of punishment for several offences. In the most ancient times, capital sentence was executed in the most barbaric and inhumane manner. Gradually, its implementation was made simple to ensure the protection of the rights of the prisoner who had to face the gallows. As the criminal justice system becomes more refined, capital punishment started receiving severe criticism, and the criminologists, penologists and theorists started emphasizing that capital punishment does not actually fulfill any normative and utilitarian purpose. This proposition impacted the penal policies across many countries, and international initiatives led to the abolition of this mode of punishing the wrongdoer. Capital punishment is a hotly debated aspect between the countries who want to retain it and the countries who strongly demand its complete revocation from the law books. In the Indian context, capital punishment is a mode of punishment for serious offences against the individual, state and the nefarious acts of terrorism. In the recent years, more offences have been added with regards to invocation of capital punishment. The popular public opinion is also in favor of death for the serious offenders like gang rapists and terrorists. Another important aspect in the matter of awarding capital punishment in India is the wide judicial discretion, as the judge can give death sentence in the rarest of rare case. The rarest of rare case principle for the invocation of death penalty has been criticized, as it involves a lot of judicial discretion. Furthermore, once the death sentence is executed, it becomes irrevocable. To conclude with the words of Sir Winston Churchill, the mood and temper of the public in regard to the treatment of crime and criminals is one of the most unfailing tests of the civilization of any country. A calm, dispassionate recognition of the rights of the accused and even of a convicted criminal against a state, a constant heart searching of all charges with the deeds of punishment, tireless efforts, there is a treasure if you can find it in the heart of every man. There are the symbols which is the treatment of crime and criminal make measure the stored up strength of a nation and are signs and proof of the living virtue in it. Thank you very much.